Hello everyone, I am Advocate Neerav Khare from Yourlordships. Today, in continuation of my video lecture series, I will be dealing with clause C of section 6 of TPA, which says that an easement apart from dominant heritage cannot be transferred. Now, what does that mean? To understand this topic, you need to understand firstly that what the law of easement is all about. See, under the law of easement, basically it gives a right to one person to exercise his right over another's piece of property. Means there is one dominant owner who will be using the property of the other person for his benefit. He will be called as a dominant owner. Why? Because he is an exclusive owner of his own property. And while he is using his right over another piece of property, over another person's piece of property, that person for him will be called as servient owner. His property for the dominant owner will be the servient heritage. So there are two types of property, dominant heritage and servient heritage. Dominant heritage is occupied by the dominant owner and servient heritage is occupied by the servient owner. So whenever the dominant owner uses the property of the servient owner as a matter of right, that right is called an easementary right. See, it is basically an incorporeal right. It is always lie with the dominant owner. Now you would be thinking that how this right can be given to someone to exercise his right over another's piece of property. See, law of easement says that it is a right of necessity. I give you an example. Suppose there is a piece of agricultural land and around the borders of that property there are different properties belonging to different owners. Now if you want to come over your property, you are required to go through the property of another person. So whenever you will be coming from the property of another person, obviously you will be committing an offense of trespass. I hope you would agree with me that if you want to come to your property, you will have to come through another piece of property. So it is an act of trespass. But easement says that if you want to reach out your property and if you need to go through from another person's piece of property, that will not amount to an act of trespass, rather it will be an act of necessity. Because if you do not do this, then another option available with you is that coming to your property using helicopter, which is a impractical idea. So you will have to come through someone else's property if you want to reach out to your property. So whenever I exercise my right over another person's piece of property, that right is called as easementary right. Because I am the exclusive owner of my property, I can use my property as I wish. But if I exercise my right over another person's piece of property, that is known as easementary law. Now, I am coming to the point. Section 6 clause C says that suppose if the dominant owner wants to transfer the right of the servient heritage to third person, can he do so? Is it possible? Is it allowed under the law? See, this is an impractical idea. It is not allowed. Why? Because we provide easementary right to the dominant owner only who is occupying the property. If the dominant owner transfer the right of the servient heritage to his friend, see, it makes no sense. Because I give you an example. Suppose the property is located in UP. I am residing over there. I am the dominant owner of the property. Now I transfer the right to my friend who is living in Kerala. Now what will he be doing with this right of servient heritage? Is he coming to UP? Is he coming to use the agriculture property over here? No. It is only me who will be using the property. So I need a right of servant heritage to rest with me. It is of no use of my friend living in Kerala. So if I transfer that right to my friend living in Kerala, it makes no sense. This is what section C of clause 6 says, that if I want to transfer my property, then I can transfer my complete property altogether. The right of servant heritage will automatically be transferred to that person. But if I keep that property with me, if I keep the ownership of that property with me, if I keep the possession of that property with me, but I transfer only and merely the right of servant heritage to my friend, it makes completely no sense. इस चीज को मैं आपको एक साधारण तरीके से भी समझा सकता हूँ। अगर आपको ऐसा लगता हो कि मैंने आपको बहुत ही बड़ी बात बताई हो तो मान लीजिए कि मेरे हाथ में एक तरबूज है और मैंने कहा कि वो तरबूज खाने का अधिकार मैं आपको देता हूँ। पर सवाल ये है, जब तरबूज मेरे हाथ में है तो आपके पास अगर खाने का अधिकार आ भी जाए तो आप उस अधिकार का करेंगे क्या? क्योंकि तरबूज तो मेरे पास है। पर सपोज कीजिए अगर मैं पूरा का पूरा तरबूज आपको दे दूं तो मेरे को ये कहने की ज़रूरत बिल्कुल भी नहीं है कि इसको खाने का अधिकार भी मैं तुमको देता हूँ। क्यों? क्योंकि ये इम्प्लाइड है। अगर मैंने तरबूज आपको दे दिया है तो खाने का अधिकार ऑटोमेटिक आपके पास चला जाएगा। आई होप आई बीन एबल टू मेक थिंग्स अंडरस्टैंड कंप्लीटली। सो थैंक यू सो मच माय फ्रेंड्स।